Hello, John Tompkins, the Defender, coming to you with another quick question that I had today. Today, the question was, what do I do if I'm contacted by law enforcement and they want me to come in and give a statement? Well, first and foremost, no surprise, call an attorney and get some advice. But generally speaking, as a general rule, keep in mind there are really only two reasons that law enforcement would want to talk to somebody. That's either they're a suspect or they're a witness. So make sure you ask, which are you? Are you going in to speak to them as a witness, or are you a suspect? Sometimes they call that a target of an investigation or person of interest. So when you have them in that first conversation, ask them, do you think I'm a witness, or am I being questioned as a suspect? Once you know that, it's easier to make the decision because your risk factor is a lot more if you're a suspect or a target, and it's more likely that you'll need to have an attorney handle this encounter if you decide to go in and speak at all. Now, if you're just a witness, I still recommend you write down what you have to say. Check your phone, check your blogs or journals if you journal. Make sure all the information that you may have written down at the time of the incident they want to talk to you about is fresh in your mind. And don't hesitate to take copies of those things, pictures, texts that you may have sent to people about these things. And it's important to keep that fresh in your mind before you go in to talk to anyone about a serious incident, because you want to be consistent. And if it's been a while, or even if it's just been a couple of days, the things that you wrote that day may not be the way you remember it now because you've talked to some other people and you've incorporated some of their memories. So go back to find anything that might remind you of what it was you saw, and only what it was you saw versus what it is you may have heard since then. Write that down, have it handy, keep it with you. If you're a suspect or a target, take that with you to the attorney you call for advice. Because if you're not a witness, if you're being questioned because you are a suspect, there are usually only two reasons the police want to talk to you. One is they do not have enough information to charge you with whatever offense they're investigating, and they want you to make admissions. I'll talk about admissions in a second. And that strengthens their case and maybe gives them enough to arrest you. Or two, they have a weak case, just barely enough to charge you, and they're hoping you'll make some admissions, or maybe even a confession. Again, I'll talk about that in a second. And then their case is strong all of a sudden. So those are really the two main reasons that the police want to talk to a suspect. If they had enough to arrest you, they'd be going to a judge and asking for an arrest warrant, not calling you and asking for a statement. So what do I mean by admissions versus confessions? Well, hardly anyone goes in and says, I did it. Okay. And if they think you did it, hardly anyone goes in and talks them out of thinking you did it. So you're not going to go in and confess, but that doesn't mean you're not going to help them if you go in and speak with law enforcement. And by that I mean help them build a case against you as an individual, as a suspect or target. An admission is just a fact that they're not sure of, and they might need someone else to corroborate, like being at the scene. So say you're asked a question, well, you were with John Doe on Thursday, weren't you? And your answer is, well, yeah, but John and I just stayed at my house. We didn't really do anything. Well, now they know you were with John Doe. And chances are they probably know where John Doe was. So they know if you're telling the truth or lying about you and John Doe being at your house. You haven't confessed to anything, but you've admitted something that makes it easier for them to, one, maybe prove you're lying if it's not true, and two, not have to look at anyone else. They don't have to count on John Doe anymore. They don't have to go get Ring doorbells to show that you were with him or not with him. You just admitted you were with them. So be careful about the concept of admissions versus confessions. Now, the next thing, sorry about the lighting, the next thing that you need to know the difference in is a statement versus an interview. When they say, would you come in and make a statement or could we question you, what they're really asking for is an interview. You may make a written statement, again, you should go to an attorney, have that person, that attorney, help you draft it for your signature, not theirs, and then decide after you've got it all written down and you know it's accurate and you can corroborate what's in it, decide whether you want to provide that to law enforcement or you just want to provide it to your attorney and let him speak with law enforcement's attorney, which is not the law enforcement officer, by the way. They're working with the prosecutor. Yep, they've got an attorney. You should too. So I hope this has given you the basics that let you ask intelligent questions when you get a call, or if you get a call from law enforcement asking you to come in and give them an interview. I hope it gives you enough information to contact an attorney and ask good questions about the scope of representation, what they can do for you and what they will do for you, and more importantly, know what a good answer might be before you decide who should represent you if you ever find yourself in that situation. This is the Defender, John Tompkins, here in Indianapolis, Indiana. I hope this has been helpful. Actually, you know what? I hope you never need this. But if you do, I hope it's helpful.